All rise.
Good morning, ladies and gentlemen. Welcome to an oral argument session of the 5th District Court of Appeal. As the Marshal said, I'm Judge Orfinger, and I'm joined on the panel this morning by Judge Thomas Sawaya on my right and Judge Bruce Jacobus on my left. Judge Jacobus is our newest addition, and we welcome him to his first sitting, although yesterday was actually his first, but his first session with our court. If you have any cell phones or pagers, we would appreciate it if you would turn them off so that we're not distracted. We have a criminal case to begin with, so each side will have 15 minutes, and appellant, you can reserve some time, and it'll show up both on the timer on the bench, as well as I'll try to give you a signal if you'll just let me know how much. In the civil cases, the parties will have 20 minutes. So with that, we'll go ahead and call the first case, HUGO KLADIVKO versus State.
Good morning, Your Honors.
Good morning.
My name is Michelle Lucas, and I'm with the firm McDermott and Lucas, and I'm here representing the appellant, Mr. HUGO KLADIVKO.
Could you try speaking up just a little bit?
Absolutely.
Thank you.
I raised 3 issues on appeal in this matter. I'd like to reserve 5 minutes for rebuttal if possible. My first point on appeal was that the trial court erred in denying appellant's motion for mistrial. In that argument, the Keith Frick was the victim's, the decedent's son, and he testified that there was an abusive relationship. And there was immediate objection by trial counsel, and they moved for a mistrial because basically saying, you can't unring the bell, this is bringing prior bad acts. And as I've argued, the abusive relationship, that terminology seems to indicate a continuous type of a situation, because of the relationship. That was ongoing and not just a single act. And my argument is that this deprived him of a fundamental right to trial. And the reason why this is so egregious is his whole theory was self-defense in this case. And if you look...
You don't think the curative instruction helped or fixed it?
No, I don't. The curative instruction and that was given wasn't given until they objected. They had a side bench conference. Then I looked at the transcript, and actually they recessed.
They took the jury out, I think, didn't they?
Right, and the jury definitely heard the...
The court asked the defense to prepare it.
Right, ordered them to prepare the curative...
But, and they did it. I mean, they did it under... They preserved their right to raise the issues that you're raising here, correct?
Right, it's very clear from the record it was preserved.
The court did say, disregard that. There was no evidence of any abusive...
relationship.
You don't think juries understand when you say that, or...?
No, I don't think in this case. And the cases cited here are all usually immediate. There's an objection, and immediately a move for mistrial is denied. Bingo, here's your curative instruction. So that it's not highlighted. Here, I believe it was highlighted significantly because this is her son saying abusive relationship. He obviously had a close relationship with his mother. Talked to her the night of the murder.
They didn't ask him a question about that. He just kind of blurted it out. I mean, wasn't that what happened?
Well, he did.
That really wasn't the question. He just wasn't responsive.
What was interesting in this case is the state said, and then on direct, and did there come a point in time when she told you, I don't want you to go into all the things that she said, right, because much of that is legally inadmissible hearsay. Mm-hmm. Unfortunately, there was no objection at that moment. Later on, he asked, but I did want to ask about her intentions. Did she tell you about the decision she made and her intentions? Yes, sir. What did she say? She told me that she couldn't take it anymore, she wanted a divorce, and she had to get out of the abusive relationship. And that's when there was the objection by the counsel saying you can't unring the bell, the abusive relationship. You know, obviously the jury hearing this remark, I don't think they could disregard that. You hear his son saying this, they're going to think he's a wife beater. You know, and it just goes to show, you know, I mean, basically wiped out his self-defense claim in allowing this type of evidence in. You know, and then compounded on the fact that the jury had this extra time frame to reflect on it. They obviously knew something was up. They, you know, they removed the jury. The judge took a recess. He wanted to consider whether to grant or deny the motion for mistrial. So they got to ponder on this. And then again, bring to the jurors' attention that they're, you know, that they shouldn't look at any of this, you know, abuse. And I just don't think the jury can just forget something like that coming from the
even though the court says, look, there's no evidence of any abuse.
Even though the court says there's no evidence of any abuse, because I believe because it's the son stating this, the jury is going to go to the next level and say, my God, the son's going to know if there's abuse. Maybe if it came from somewhere else.
He was reporting what she evidently told him, I suppose.
Right, and
he didn't say, you know, it was an abusive relationship. I mean, he basically was reporting what, I mean, and again, unsolicited, what his mother had said, right?
Right, unsolicited with what his mother had said, but they had in the motions, the preliminary hearings, they did have motions, and you know, the state admitted
they
this
agreed, no, that was coming
inadmissible. You know, that it could come in about the divorce, but certainly not about, you know, well, they didn't even know with him any abusive relationship. He never mentioned any type of physical or abusive relationship as far as that goes. And I think it was more even compounded and highlighted because of the earlier comment by the prosecutor. The prosecutors bringing to the attention of the jury, I don't want to go into all these things that she said because much of that is legally inadmissible hearsay. And I know there's no objection here, but I'm saying because of the objection just 2 sentences later on the abusive relationship, it gives the jury the clear impression, boy, there's a lot of stuff that we're just not being told. You know, and then all of a sudden he's, you know, how is his self-defense theory? I mean, it obviously deprived him of the right to a fair trial under this circumstances. You know, and we do have, you know, the state had argued, let's see, there was a recess. Oh, what I wanted to say is there was a recess. That's why I believe they had longer time to think about this point. And further, this court did say in Bryant, it was the case of Bryant, and there was a delay in that case. You know, it wasn't given till the next morning, the curative. And this court did find that that was not error. But in Bryant did not rest on any self-defense theory. It was contained in that. And the state also is arguing in their brief that that it was an isolated single comment in a 3-day. Read this, and as I said, I believe it. You know, yes, it was a single comment, but and you know, arguing that it's no specific incidents of violence.
You would agree that the standard that we apply is abuse of discretion, and that we presume that when the jury was given the curative instruction that they understood it and followed it. Would you agree with that?
It is an abuse, you know, abuse of discretion standard. You know, I don't believe harmless error applies because of the Goodwin case, but it's basically still whether his fundamental right to a trial.
And based on the instruction that the judge gave, you feel that it was an abuse of discretion for him to deny the motion for mistrial?
Absolutely. You know, I think in this type of case where, you know, he's being tried for murder, second-degree murder, and you have this abusive relationship, it wasn't just even one single prior incident. Even that would have maybe reduced the harm, but when you're relying on a self-defense theory, the state basically was able to use inadmissible hearsay evidence in order to get a conviction.
Do you agree that we are to presume that when the curative instruction was given that the jury would understand it and follow it, and that unless that presumption is overcome, that we stay with that presumption?
I'm not sure as far as with the abuse of discretion. I guess you do have to look at it and say, yes, did the jury, but I think you also have to look at it in just common sense also. How could that, and did it deprive an appellant of his fundamental right?
But I understand you want us to use common sense.
Pardon?
You want us to use
Yes, I
common
want you to use some common sense, and I think
You're probably in the wrong place.
looking at the totality
We got a problem here.
of the circumstances, and in this court, in their other case, I can't pronounce the Canataris, just says you can't unring the bell. And I don't think here you can unring the bell with such a prejudicial comment coming in and them using these prior bad acts. We don't know what effect it had on the jury. Obviously, they're going to, it's going to sway them whenever, that's why.
Can you ever unring the bell? I mean,
I believe so. You can unring the bell. I mean, I think in the case of Walker, there was a Supreme Court case.
Mm-hmm.
And but the fact pattern was different in that case. That was, when it brought up sexual assault where he was only being tried for murder. Where here, stepping from an abusive relationship to murder, I think is an easier step for a jury to make versus the clear curative instruction. And in Walker, it was immediate instruction. In most of the cases, it's immediately done. And as I said here, they had the recess, and this prior bad acts just should never have come before the jury. So the state was able to use that. My second point on appeal was the lay opinion testimony that was allowed to come into evidence in this case.
Do you think it would have been proper for the EMT to say that well, let's kind of break down what the EMT said as it relates to your concerns. Is it proper for the EMT to say, when I got there, which was, and apparently it was undisputed, it was about 25 minutes after the 911 call, when I got there, the body was cool to the touch. That was okay, wasn't it?
I don't think there was any problem with saying
Okay.
that.
And
that was
as
the
far
first
as, and you're down to 4.5 minutes, by the way. So I'll ask this quickly. Is there a problem, do you think, if the EMT said the body had the early stages of rigor mortis?
Yes, I do think that's.
You think that EMT, with her training and her experience with 100 or so deceased persons, should not have given that opinion?
Right, because throughout the whole thing, as they're trying to lay the foundation and everything, there's nothing that she says that we've learned, any education that we've learned to identify how long, the length that a body's been, how someone has been dead for how long. And there's nothing in the entire record on her accuracy. And here she's allowed to put in this testimony that, that she's been dead for over 25 minutes. And it's like, well, where'd she come up with this figure? And how could she? And the harm there, and it's definitely harmful to the defendant, and especially in light of when we look at the
well, the trial judge finally figured that out, isn't that true?
Yes, but it was already out there.
It was already out.
It was already out there at 25 minutes.
And they did kind of a voir dire over qualifications outside the presence of the jury. And
yes, some of it was done outside the presence. Then he decided no, and then
right,
he was not letting anything else in. And this was, I believe, extremely harmful because, again, this is a self-defense case. And when you look at the closing argument of the state, it's highlighted in there.
And the argument was, really, the defendant waited a substantial period of time before he called 911. Is that what they kind of argued?
Yeah, absolutely. I suggest to you that the only part of the cover-up that he concocted, and that's the reason Mrs. KLADIVKO's body had gotten cooler, because there wasn't 25 minutes between the time she died and the time the paramedic arrived. It was longer than that, even if the warmer part of the house. So he goes on to say that basically because we have this time lapse, and that's why it's so important to the state's case, is therefore, he staged. She was able to stage this whole situation. And that's why it's so prejudicial in this case, and allowing a lay opinion testimony, who we have no idea. I mean, there was nothing saying, yes, I've seen 100 bodies. Okay, great,
Well,
I
mean, the
give
trial-
her that.
Clearly, the trial judge reached the same conclusion that
You
you're
know,
advocating here, but
as
it
far
was
as-
already out at that point.
So I think with, as far as the point one with the motion for mistrial and allowing in the abusive relationship, and also with, having this woman testify as to the time of death was improper and appellant should be granted a new trial. My last point was number 3, and that was regarding the abuse of discretion again with the judge.
That's clearly, the view issue is clearly in the trial court's discretion, though, is it not?
It is in the trial court's discretion. However, it should be. It's still subject to abuse standard. Right. And it's also looking at, would the jury view have aided the jury in making a decision in this case? And, to look at photographs and a video, they had an auto sketch, but the point is that's not the same as being there. And again, this was a self-defense case. If it's an identification case, well, we don't need to be in the home. And it seemed, from remarks from the state, advising the judge, this is, you have broad discretion in this area, but, this is going to take a half a day.
Trial judges worry about things going real wrong at views, don't they? I mean, that's one thing.
Right, they have to be very careful and, and how it's, how the view is conducted.
Right.
But I think under this situation, to be able to tell how high, what type of an area they were in, where did the struggle, I think it would only have aided the jury, and especially as here we have the self-defense.
There were photos, were there not? A lot of photos. There was a DVD of some kind?
And there was a DVD, yes.
Yeah. Okay.
And, I would say that does not,
Not the same?
it's not the same as being in a place. All right, I see my time is up.
Actually, you've got 7 seconds left.
I have 7 seconds.
I'll give you another minute when you come back on rebuttal if you'd like.
All right, thank you.
We could sell that. Kind of like a cell phone.
Yeah.
May it please the court, my name is Chris Davenport and I represent the state. As the issue 1, we're talking about a single comment in a 3-day trial, and it's a vague comment. It's not like the son said, I was glad she was leaving because I've seen her bruised and battered so many times I can't even count. That would be a more difficult case. I mean, in that case, we have evidence of physical abuse, and that would clearly be prejudicial. Here we have her saying it's an abusive relationship. We don't even know what that means. For all she meant, he's emotionally abusive or he's verbally abusive. So in light of the nature of that comment and the curative instruction that was given, it was a strong curative, disregard this, there's no evidence of this, the jury can follow instructions. We have to assume that they do that. Clearly this did not warrant a mistrial in light of the nature of the comment and the other evidence at trial. As to issue 2, the paramedic testified that the body was cold. She talked about the temperature in the house.
She gave an opinion that probably she wasn't qualified to say, don't you think?
Well, I think she was qualified to say that.
Trial court didn't, though, did it?
The trial court didn't allow her to go into it any further and say, yeah, it's been 45 minutes.
I mean, the cat was out of the bag then, but I mean,
Right.
I think the trial court clearly, when outside the presence of the jury, they determined, really, she hadn't taken any temperatures.
Right. She didn't take the temperature of the body. She just went by feel, the body was cold. But when you look at the standard, it's specialized knowledge that'll assist the jury in evaluating the evidence, then that's admissible. Clearly a paramedic who has seen 100 dead bodies has specialized knowledge. And, saying it takes a while to get cold.
I don't know that I would agree. It seems to me that there's a little bit of difference. I mean, if I've seen 100 dead bodies, that doesn't necessarily give me that level of expertise. I think the real question is, what level of expertise does she have? What experience or training does she have with dead bodies that would let her give an opinion that either A, a body doesn't get to room temperature in 25 minutes, which is essentially what she said, or B, you don't get rigor mortis or the early stages of rigor mortis in 25 minutes. I mean, I think the state was pushing the envelope, at least without having laid any predicate as to her expertise in those fields.
They did not lay a very good predicate in her expertise as to how long it takes. They didn't ask that extra question. Let me say about the rigor mortis, that was proffered while the jury was out of the room. She didn't testify about rigor mortis. The only thing she said in front of the jury was, the prosecutor said, do you think it was more than 25 minutes? And they used that time because it had been 25 minutes before she got there from the 911 call. And she said, yeah, I would speculate it would be more than that. The body was cold. You know, I think she's entitled to say it takes a while. I don't think she could put a time frame on it, but it takes a while for a body to get cold. I mean, the victim wasn't a vampire. It takes a while. It wasn't, you know, the middle of winter outside up north. It was Florida in May. You know, the air was set at 76, so it wasn't freezing in that house. I think she could say
Well, she
that
didn't measure
much.
the air temperature, did she?
No, but somebody else did.
Did they?
Yeah, there was testimony that it was 76 degrees in there. So, you know, all she said was she explained that it takes a while for it to get cold. And let me also say that the defendant said that after the wife died, he wandered around for a while. He didn't call 911 right away. He went in, he was going to call 911, he grabbed the phone, and then he said, oh, I'm not sure what my address is, because he was confused, so he had to go into the den. This is an older man, you know, you can presume that this wasn't real quickly happening. So it's not like the exact time frame of when this happened was dispositive. We know that the son got off the phone at 9:10, 9:15, and 911 was called at 10. So it was a short time frame anyways. It's not like the time of death was the only thing that tied this guy to the murder. His claim was self-defense. He had a single puncture wound on his left arm that had already clotted by the time the paramedics saw him. So, you know, she had so many wounds the medical examiner couldn't describe them all. This isn't a real close case. This was clearly, she was brutally attacked. And let me also say, I don't think that this claim was preserved. Their objection was after she had already said it. They objected initially to lack of foundation. The prosecutor tried to lay more foundation. They didn't object again before she actually got out this 25 minutes. But at worst, if she shouldn't have said that, it was harmless error. As to the jury view, there's a bunch of pictures here. There's a DVD. There's a diagram of the scene. This wasn't one of those situations where how it happened, you know, the exact locations was dispositive. I mean, it's a house. It was the defendant's house. If he wanted a better DVD, he could have shot one. So I think the court acted well within its discretion in denying a jury view. In light of all that, we would ask the court to affirm. Thank you.
Thank you, ma'am. You can have 1 minute and 7 seconds.
All right. In response to the abusive relationship, the state argued that it was isolated and that, you know, the jury could infer that it was mental abuse. I believe, given the fact that this is a murder case, the only thing that jury was going to infer is that there was physical abuse. With the paramedic training, yes, she had paramedic training, and as we said before, has seen, you know, numerous bodies.
Do you think the objection was timely made? I forgot about that.
Yes, I do.
You think it was?
You know, I think they had objected initially when it came out, a lack of foundation. The court sustained the objection, and then they continued, and then it was outside, and then the state, defense counsel objected again, and the state overruled the objection, and that's when she was able to bring in, it's been, you know, I speculated that she'd been down longer than 25 minutes. That the call was received. And as I said, in this case, that was just so prejudicial, since the closing argument highlighted this whole feature of this time with the self-defense.
All right, Ms. Lucas, thank you so much.
Okay, you're welcome. Thank you.
Out of time.